This is for clarification and informational purposes because I've been getting a lot of messages asking, sir, I'm a short service officer. Should I fill up the Google form? Should I send the legal notice? Should I become part of the PC and reinstatement cases? I am a serving officer. So, it becomes difficult to answer all these queries individually, even by messages or on phone calls. So I decided to make a longish video, especially because, there are certain things which I also have had in my mind regarding sending legal notices to the government for asking pensionary rights. So this is an attempt by me to cover all the ongoing pensionary issues of SSCOs and PC and reinstatement cases. Jai Hind. This is an update regarding the ongoing court cases in the Honorable Supreme Court, High Court and AFT regarding the pensionary rights of SSCOs. We know that a lot of cases have been filed. Pro rata pension case, which was ongoing in the Honorable Delhi High Court. This is writ petition 2098 of 2018 and another writ petition, the number of which is just escaping my mind right now. So anyway, these two cases have been reverted or have been relegated or remanded by the Honorable Delhi High Court to the AFT. It was listed in 3-4 days ago, that is I think on 29th of September, and has now been listed again on 21st of November. So basically these pro rata pension cases which were in the Honorable Delhi High Court for almost 7 years are now being heard in the AFT. It is being also encouraged that all short service officers send legal notices to the government. I don't understand the utility or the requirement of it or the benefit of doing this, because in whatever hundreds of cases I have filed or heard or witnessed in the AFT or High Court or Supreme Court, there is no requirement or no utility of serving a legal notice in this kind of matters, wherein essentially what we are asking the Honorable Court to do is to issue a writ of mandamus to the government. Writ of mandamus means issue that the court is calling upon the government to take a certain action which it is bound to take, or to refrain from taking a certain action which it is not entitled to take. This is a writ of mandamus. So we are essentially asking the government, we are essentially asking the court to issue directions to the government to create some provisions for equality of a pro rata pension in favor of short service commission officers. There is absolutely no legal requirement in my knowledge of sending a legal notice to the government in such cases. I may be wrong. I am a student of law. In case I am wrong, please enlighten me. This is what I actually wish to know, that what is the legal requirement or validity of sending a legal notice in such cases. Having said that, I certainly very strongly disagree from the idea that everyone should be rampantly sending legal notices on this issue also. See, there are some nearly 3,000 officers who are part of, at least 3,000 officers who are known to me, who are part of different kinds of cases pending before different courts for different sorts of pensionary benefits. If you talk about pro rata pension matter, so nearly 2,000 officers are part of this case. If you are already part of a pro rata pension case filed by any organization, any association, or filed by you individually in your individual capacity, and you are also a signatory to this kind of a legal notice, there are two problems. One is, first of all, by sending a legal notice, I don't know how you can be possibly benefited. Okay, because by sending a legal notice, you do not become party to any ongoing case. Okay, without submitting a wakalatnama, a power of attorney, or an affidavit, without giving any kind of a document to your lawyer, which he submits in the court, which you have signed in ink, I don't understand how you can become a party to any case, unless it is a case by an association or an organization. Any association or organization you should not become a part of if you're a serving member of the armed forces. This is categorically mentioned in Army Rule 19 and Army Act Section 21. You can Google it. I also have it, and I can read it out also. See, people who are retired, they can form part of associations and organizations, that is fine. But still, without giving a, unless that organization or that association is the applicant or the petitioner, I don't understand how merely filling up a form online makes you any kind of a petitioner or applicant. If now talking about applicants for the AFT, any association or organization cannot really be an applicant. Okay, it has to be an individual before the AFT, as per the procedural things of the AFT. Now, but let us say in whatever way you can become a petitioner or an applicant by just filling up a form and by just sending a legal notice. Now, what is the problem with this? If, like I was saying earlier, there are nearly 3,000 some officers who have filed different kinds of cases for different kinds of pensionary benefits. Suppose you're already a petitioner or an applicant for whatever kind of a pension, let us say for pro rata pension, whether you are a petitioner like this in your individual capacity or a petitioner like this as part of some association or organization, but you are becoming part of another court case for the same thing, that is pro rata pension, then this is abuse of the process of law. This is abuse or misuse. The court is likely to dismiss both cases against you, okay? Or is also additionally likely to impose costs on you or your lawyer. See, for one subject matter, you cannot file two cases either in the same court or in two different courts. When your prayer is the same or your grounds are the same, you cannot file two different cases in two different courts. You have to in fact give a declaration that such a case is not pending in any other court. I also fully believe that short service officers should be united, but our unity has to be in such a way that it is advancing our cause and not is detrimental to our cause of pensionary benefits and equality. Because I feel that if you are doing something like this, you are a petitioner in two cases filed for the same prayer, filed for the same relief, then it is going to be definitely detrimental to the overall cause of the Short Service Commission Officers fraternity. In case anyone wants to discuss, I am available for discussion on these subjects. So pro rata pension, I feel, is a great thing. Pro rata pension, in my opinion, can be sought by, there's no policy categorically laying out that officers are entitled to pro rata pension in any circumstance, but it can be sought by officers who are similarly situated. Like, it has been given to officers earlier. It has been given to officers in 12 to 14 years of service only, in Lieutenant Commander Annie Nagaraj case, in Wing Commander A.U. Tebba case, in Anupama Joshi case. So the best grounds for asking for pro rata pension are that you were good enough, you deserved a PC, but you were not granted a PC because there was no option for PC for you. Or, so this mostly applies in case of women officers. Or let us say you were offered a PC later on, but by then you had already moved on, like in Anupama Joshi case it has happened. Or, some situation like, let us say you became disabled, which is attributable to military service or naval service or air force service, and therefore you could not be granted PC. So basically you were good enough, but the organization could not grant PC to you, so you were removed from the service for reasons that were beyond your control. This is a good ground for asking for pro rata pension. But if people who voluntarily moved out of service, they come and later on ask for pro rata pension, I don't think it is a valid ground at all. I'm being very honest about it. And because this kind of cases, even civilians are not allowed, pension. For civilians also, under the CCS pension rules 1972, you become pensionable in 10 years of service, but you cannot take PMR, that is premature retirement, or in civil terminology it is called as VRS, voluntary retirement scheme. You cannot take that before 20 years. So let us say after 10 years, between 10 and 20 years, for whatever reasons beyond your control, your services are discontinued, then you become entitled to pension. Let us say you die after 11 years of service. So then you will be pensionable. But you are resigning from your civil job after 12 years or 11 years, then you are not entitled for pension because you cannot resign. So basically, if you want to take pension in a civil government setup also, you have to serve for 20 years minimum. I know people will say that civil is different from the military setups, but I think it is a very weak ground, because when you joined services, you knew that your service is not pensionable, okay, and you are coming out voluntarily also. You are not wanting to serve. Pension can be claimed by officers who wanted to serve, who were good enough to serve, who were in shape 1, or there are some branches, especially of the Air Force, and especially for women officers at various times, or even in the Navy, when there was no option for PC. So you were good enough, but you were not granted PC. So this is a good ground for a pro rata pension, but I don't think that anyone else, it will be very difficult. So compared to this, the Unified Pension Scheme and NPS and CPF is based completely on the ground of fundamental right to equality, that all other civil and government servants are getting it, so why should I not be getting it? So there's no possibility of arguments against it, except the very frivolous argument that no contribution was made by the officer towards the contributory pension fund or towards the NPS scheme or towards the UPS scheme. But that is a very wrong argument, because we have been making contribution to the DSOP fund. So actually we should not have been placed into the DSOP fund. This is what I've explained multiple times. We should have been placed in a contributory provident fund, but DSOP fund is not a contributory provident fund. So I have written, to the Honorable CJI, requesting them to take suo motu notice of the fact that SSCOs are being, unjustly dealt with, and we've requested them to issue directions, to consider the feasibility of issuing directions to the government to come up with any policy or scheme which ensures pensionary benefits, at least for officers who have petitioned various courts over the last few years. So, and pointing out that this will not significantly enhance the pension load on the government, because in a nation of 140 crore people, where millions of people are already in receipt of different kinds of pension, if you add 2,000-3,000 officers to it, it is not going to make a substantial difference in the percentage of pension load which the government is already under. So I believe that, and this unified pension scheme is a very similar concept to the pro rata pension issue. The government itself is, I think, proposing to at least a proposal is being sent or has been sent to the 8th Central Pay Commission to include UPS or DBS or DBC for short service commissioned officers. This basically, so this DBS is defined benefit scheme or defined contribution scheme, something like that, which is on the lines of contributory provident fund. So according to this, you contribute 10% of your basic pay into this contributory fund or into the UPS type of scheme, so into this contributory fund, and the government contributes 18.5% into that. So if you, as per their calculations, a major retiring at 10 years of service will be getting a pension per month of nearly 19,000 rupees. A lieutenant colonel will be getting it of nearly 39,000 rupees. I don't think it is a bad thing at all. This is exactly what people are aiming in the pro rata pension case. Also, the maybe the one difference which would be there is that they can argue that you never contributed to this contributory fund, but our answer is that we have been already contributing into the DSOP fund. Still the difference is that the DSOP fund was given to the officer upon his release from service or upon his retirement from service. So there might be a requirement that we may have to contribute, or we might have to give a one-time large amount of money to the government, but then it will all be coming back to us in the shape of the UPS or NPS, whatever it may be. Also, some officers think that let me stay away from this case because for whatever reasons, I just want to see and observe what is happening. Let me tell it to you I am convinced about it. Even if courts give a favorable order, the order will be applicable as a judgment in personam and not as a judgment in rem. That is to say that it will be a judgment personally for people who are part of those cases and not a judgment for the world at large. So basically, only people who are part of these cases will be those people on whom the judgment will be made applicable. Other people will be left out of it. Also, so now there may be scope for other people to thereafter approach the court, but many times what the courts do is that they close options for remaining people, even though they are similarly situated, to petition the courts for similar matters. Reason being that opens Pandora's box of troubles for the government. Okay, so let us say 1 person or 10 persons get the relief. The court will say that, okay, fine, we are giving it as a one-time measure. Other people will not come to us, will not be allowed to come to us, citing this case law and asking for the same relief, even though they are similarly situated. Okay, this is fortunate or unfortunate, but that is how it is. In Lieutenant Colonel Suprita Chandel judgment, the Honorable Supreme Court had said that people who are similarly situated need not come to court, and the organization should itself extend the same benefit to officers who are similarly situated, to people who are similarly situated. But the organization or the MOD is currently not doing that for whatever reason. So what I feel is that unless you're part of these cases, you're not going to be benefited, whatever the benefit may be given by the court. I am open to discussion on these points. I am, with whatever knowledge I have, I feel confident about these things. But in case I'm wrong, I'll be happy to discuss and be proved wrong and, enhance my knowledge in the process. But I don't think that serving this legal notice can serve any purpose at all. So I will strongly advise serving officers to not join any association or any organization. You are completely free to file any cases in your individual capacity. You are not required to inform your employer. There is no harm in informing your CEO or your employer or your hierarchy that you're filing a case, but there's no requirement of doing that. There's no requirement of taking a permission either, and you're not required to be present in Delhi or anywhere else or in any court of law if you filed a case for your pensionary rights or benefits. Also, regarding the UPS, NPS, CPF case for which multiple original applications have been filed in the learned AFT, each of these OAs being voluminous, the AFT is taking a substantial amount of time to go through the entire number of pages and pointing out the defects in it. We are aiming to, for an early hearing, but we cannot be sure when that is going to happen. Some individual officers are also going ahead with the UPS, NPS, CPF cases, so their cases also may be listed anytime soon. In the meanwhile, we are also trying to, latch on to any other case which is going on in the Honorable Supreme Court and putting our demands regarding the UPS, NPS, CPF issues, or even the pro rata pension issue where it is applicable. Because, like I had said that we've already written to the Honorable CJI requesting for these pensionary benefits for the short service officers. I wish and pray that all officers get PC or reinstatement, whoever have approached the courts for it. But even if at least for whatever reason it fails, then at least at the very lowest minimum, what they should be getting is pro rata pension where it may be applicable, or UPS or NPS or CPF or whatever kind of pensionary benefits, or at least 20 years of service so that they become pensionable. So it is my fond hope and wish that everyone who's aspiring for PC or reinstatement get it, but there can be no guarantee. So whoever files these cases should, in the alternative, pray for 20 years of service eligibility, and still in the alternative pray for pensionary benefits. It may be pro rata pension or whatever pensionary benefits. Now this is being made in the interest of just for knowledge, just for sharing whatever insights I have, and this is just for informational purposes from my end. And I had said that I will read out these Army Rule 20. Sorry, this is Army Rule 19 and Army Act Section 21. So Army Rule 19, and there are similar provisions in Air Force rules and Navy rules. So Army Rule 19 reads like this: unauthorized organization. Unauthorized organization. No person subject to the Army Act shall, without the express sanction of the central government, 1. Take official cognizance of, or assist or take active part in any society, institution or organization not recognized as part of the armed forces of the Union, unless it be of a recreational or religious nature, in which prior sanction of the superior officer shall be obtained. So even if it is of a recreational or religious nature, you have to obtain the sanction of your boss. 2. So this is no person subject to the Army Act shall, without the express sanction of the government, central government, be a member of or be associated in any way with any trade union or labor union or any class of trade or labor unions. What are trade or labor unions? Organizations in which employees or laborers come together to ask for their rights, to ask for their benefits. This is exactly what, it is very much similar to asking for that kind of rights if you're asking for pensionary benefits. Notes. to Army Rule 19. See Army Act Section 21 and notes thereto. The fundamental right to form associations or unions enjoyed by every citizen under Article 19(1)(c) of the Constitution is abrogated in its application to members of the regular army under this rule. That is Army Rule 19. Similarly, under Army Rules 20 and 21, the fundamental rights of freedom of speech and expression and assembly enjoyed by every citizen under Article 19(1)(a) and (b) are abrogated in their application to members of the regular army. The aforesaid rights have been so abrogated because of the nature of duties performed by the members of the regular army and for the maintenance of discipline among them. Now, here this is very important. Contravention of any of the rules 19 to 21 would be punishable under Army Act Section 63. Okay, which is violation of good order and military discipline. And similar provisions are there in the Navy and Air Force as well. Now, Army Act Section 21. Power to modify certain fundamental rights in their application to persons subject to this act. Subject to the provisions of any law for the time being in force relating to the regular army or to any branch thereof, the central government may by notification make rules restricting to such extent and in such manner as may be necessary the right of any person subject to this act to, now this is point A, to be a member of or be associated in any way with any trade union or labor union or any class of trade or labor unions or any society, institution or association or any class of societies, institutions or associations. So my humble hand-folded request to any serving officers is that please do not be part of any association or organization or institution or whatever else asking for any kind of benefits. You risk being court-martialed. You can do these things in your individual capacity. You can file cases. There's absolutely no harm. You cannot do these things in a group. B, to attend or address any meeting or to take part in any demonstration. This is not relevant. Then point C, to communicate with the press or to publish or cause to publish any book, letter or other document. So I am again repeating, you can participate in this kind of cases in your individual capacity, but you cannot form part of any association or any organization or any institution or any society which is, collectively doing this kind of stuff, asking for your rights, asking for your pension, whatever your grievances may be, which may be right or wrong or whatever. But you cannot, while being in service, form part of any associations. That's all from my side. I'm still, available and open to discussions. I may be reached at my office number and whatever, in case anywhere I'm wrong, I think I'm humble enough to be corrected and be led to the right thing. That's all. Jai Hind.